attorney Laura Anthony, founding partner of Anthony PLLC, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Form S-3 eligibility. Today we are going to talk about Instruction 1B3, which is used for the resale of securities. A Form S-3 can be used to register the resale of outstanding securities held by a shareholder as long as the company meets the registrant qualifications and already has securities of the same class listed and registered on a national securities exchange or quoted on an automated quotation system of a national securities association. The OTC markets does not qualify as an automated quotation system for purposes of this eligibility requirement. When registering warrants, the warrants themselves do not have to be traded on the national exchange as long as the underlying common stock is listed. Instruction 1B3 is not the exclusive way to use Form S-3 for secondary offerings. If a company meets the eligibility requirements for a primary offering using Instruction 1B1, i.e. the market value of voting and non-voting common equity held by non-affiliates exceeds $75 million, it can use Form S-3 to register a secondary offering under that provision, regardless of whether it has a class of securities registered on a national exchange. Earnout shares to be issued in connection with a consummated merger may be registered on Form S-3 even though the shares have not been earned and are not outstanding at the time of the registration statement. Likewise, securities to be issued in an exchange relying on Section 3A9 of the Securities Act may be registered for resale on Form S-3 even though the exchange has not yet been completed. A Form S-3 may be used under Instruction 1B3 to register the resale of securities to be issued upon the conversion of a convertible security, such as a convertible note or preferred stock, prior to the actual conversion. However, the company may not register an indeterminate amount of shares. If the conversion formula is floating, such as a discount to market price, the company must make a good faith estimate of the maximum number of shares that it may issue on conversion to determine the number of shares to register for resale. If the number of registered shares is less than the actual number issued, the company would need to file a new registration statement to register the additional shares. If the number of shares to be registered is in excess of 30% of the then outstanding public float, it will be considered an indirect primary offering, and a company may only use Form S-3 if it qualifies to use the form for a primary offering under Instruction 1B1. Instruction 1B3 may not be relied upon for the resale of securities held by a parent or subsidiary, as a parent or subsidiary is generally considered an alter ego of the company itself. That is, a resale in that case would be considered a primary offering, and the company would only be able to rely on Instruction 1B1 if it wanted to use Form S-3. However, there are circumstances where affiliates may make offerings that are deemed to be genuine secondary offerings. I'm securities attorney Laura Anthony, founding partner of Anthony PLLC and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.